So, what do you do if you have a blended family? How should you pass assets to your spouse? I'm Claire at the Yanowitz law firm, where we help families protect what matters most, including helping families that are blended. Um, so when you have a blended family, there's a lot of special considerations that you should think about when planning your estate plan. And one thing that comes to mind is, how should you leave assets to your spouse? And there's a couple of different ways to do this. Oftentimes I see that blended families want to leave assets to a surviving spouse in a trust instead of outright. So at their death, their will or their revocable trust morphs into a new trust at death for the benefit of their spouse. This is oftentimes called a marital trust. And in a marital trust, the spouse is required to take out all the income annually. And then the question is whether the spouse can get at principal. Do you want to make it flexible for the spouse to get at principal? Do you want to make the spouse show need before getting at principal? Do you want them to have the greater of all income or percentage amount every year? So oftentimes people will set up a marital trust. So they'll say, well, you get all income or 4%, whatever's greater per year. And that can create a nice boundary line or a boundary of acceptability of how the spouse can withdraw assets from that trust for his or her needs, so that the children, there's basically this agreed amount that the spouse can withdraw in the trust, and it can reduce conflict with the children, that she or he isn't spending all my inheritance before I get it, that sort of thing. So oftentimes that percentage that they're able to get is enough that it's not going to dramatically reduce the principal or not reduce it at all. The spouse is going to be generally living off income and appreciation of the assets, but then at their death, the principal is safe there to pass to the children. So that is that's a major concern oftentimes with blended families. They want to provide for the spouse while he or she is alive, but then at the spouse's death, they want to have the assurance that it's going to pass back to the surviving spouse's kids, that they're going to pass to the blended family's children in the way that the two parties agreed upon during their lifetime. I know that a lot of times people get concerned that maybe their spouse might remarry. They don't want this money to go to a new spouse at death, and they don't want it to go to another spouse's children at their death. And so the marital trust can act as protection from like a new spouse or a new significant other entering the picture. So that can be helpful. Now, something to consider with a blended family is who should be the trustee of that marital trust for the spouse's benefit. And the options is you can have a person, or you can have a professional or a company be trustee. And so that's something that should be considered. In a non-blended family situation, oftentimes spouses are the trustee of their own trusts, but that sometimes is not appropriate with blended families. Not in all blended families, but something to consider, because sometimes it can be helpful to have a neutral third party be the trustee of that trust. They can make sure that the trust is being administered as correctly. Even if you trust your spouse and you feel like they would do the right thing, sometimes having that neutral third party involved can act as a good mediator between the spouse and the kids, a good assurance to the children that things are done correctly, that somebody without a self-interest in the trust is watching it over. So that is something that is considered, that should be considered, and can definitely be appropriate in these spousal blended family situations. Now, kind of a sticking point that I see comes up with blended families and what to do is retirement accounts. Retirement accounts are sticky. So when I talk about retirement accounts, I mean like IRAs, 401ks, 403bs, um, those are all sticky. And here's why they're sticky. Because a surviving spouse, if named directly, they get the longest payout on these accounts at death. So once the first spouse dies, if the surviving spouse is named as the direct beneficiary, they get one of the longest payouts of any beneficiary for these types of accounts. And so there can be an incentive to name the spouse directly, as opposed to a marital trust for the spouse's benefit, which can generally result in a somewhat shorter payout. So why does it matter how fast these accounts get paid out at death? It matters because when these accounts are paid out, income tax is paid on it. So if the account comes out faster, the income tax has to be paid much faster. Also, if it comes out in bigger chunks, it might push the spouse into a higher tax bracket. And so not only is the income paid faster, but more income tax is paid on the distributions because it forces the spouse into a higher tax bracket. So sometimes, even if the bulk of assets are going into a marital trust, sometimes people will still have their spouse be the outright direct beneficiary on retirement accounts. So that's something to consider with blended marriages. I hope. I guess one final thing I wanted to say about marital trusts here is that something that has to be considered is what happens when that second spouse dies. Where do the assets go? And oftentimes there will be default provision within the marital trust. It'll pass to our children equally. It'll pass to his kids 50%, her kids 50%. So it's going to say something. Now, we can put in that marital trust the ability to alter how it passes. And so care should be taken with blended families on how the spouse can alter how it passes, okay? So let's say a child, after the first spouse's death, gets into a horrible accident and becomes disabled. We want to give the surviving spouse the ability to reformat that child's inheritance because now they're disabled, okay? So we want to add some flexibility in the ability to alter inheritances, but the question is how much flexibility should we give the surviving spouse? So I have written trusts so that will give the spouse some flexibility, but not as much as though if it wasn't blended. So we can say, well, they can alter how the children inherit, but at the end of the day, 40% must go to wife's children or descendants, and 60% must go to husband's children or descendants. So we give them the ability to alter, but we still have certain percentages going to the spouse's respective families. So that's something else to consider. Thank you so much for listening. And if you enjoyed this video, feel free to send us, hit the subscribe button so that you can watch more of our videos as we make them. Thank you.